Case B2 of 2025, State versus Ziyaad, Hurzook, in custody. It is today, the 28th of January, 2025. Court composition is as follows. The presiding officer, Mr. Lebombo, for the state, Mrs. Molokwani. The defense, Advocate Razak. And the interpreter before court is Mr. Mukhosi, though in this matter, interpreter is not, the services of an interpreter are not needed. Our stenographer is Mr. Makaludisa. Joseph, the matter is on the roll for today for judgment on bail, as it pleases the court.
Yes, please.
May please, Your Worship, do confirm my appearance.
The bail judgment reads as follows. In the matter between Ziyaad Hurzook and versus the state, this is an opposed bail application where the applicant is charged with the following. Count 1, contravention of provisions of section 1F1 paragraph I, read with section 1, 15, 17.2, 17.3, 17.4, 17.6, 18.1C paragraph I, and 27.4 of the Protection of Constitutional Democracy Against Terrorist and Related Activities Act 33 of 2004, herein referred to as POC Datara, and section 3, or rather, and section 256 of the Criminal Procedure Act 51 of 1977, herein referred to as CPA, and further read with section 51(2)A of the Criminal Amendment Act 105 of 1997, offenses associated or connected with financing of a specified offense. The first alternative to count 1, contravening the provisions of F2, read with section 1, 15, 17.2, 17.3, 17.4, 17.6, 18.1C, paragraph I, and 27.4 of the POC Datara, and read with section 256, or rather 256 of the Criminal Procedure Act, and further read with section 51(2)A of the Criminal Procedure, or rather Criminal Amendment Act 105 of 1997. The second alternative to count 1, contravening the provisions of section 41G, paragraph I, read with section 1, 15, 17.2, 17.3, 17.4, 17.6, 18.1C, paragraph I, and 24, or rather 27.4 of POC Datara, read with section 256 of the CPA, and further read with section 51(2)A of the Criminal Amendment Act. Third alternative to count 1, contravening the provisions of section 41G, paragraph 2, read with section 1, 15, 17.2, 17.3, 17.4, 17.6, 18.1C, paragraph 1, and 27.4 of the POC Datara, and read with section 256 of the Criminal Procedure Act, and further read with section 51(2)A of the Criminal Amendment Act. The fourth alternative to count 1, contravening the provisions of section 41H, paragraph 1, read with section 1, 15, 17.2, 17.3, 17.4, 17.6, 18.1C, paragraph I, and section 27.4 of POC Datara, and read with section 256 of the CPA, and further read with section 51(2)A of the Criminal Amendment Act. Fifth alternative to count 1, contravening the provisions of section 41H, paragraph 2, read with section 1, 15, 17.2, 17.3, 17.4, 17.6, 18.1c, paragraph 1 and 27.4 of this Pogdatara, and read with section 256 of the Criminal Procedure Act. Alternative to count 1, contravening the provisions of section 3.1a, read with section 1, 15, 17.2, 17.3, 18.1b, and 27.4 of Pogdatara, and read with section 256 of the Criminal Procedure Act, and further read with section 51.2a of the Criminal Amendment Act. Count 2, contravening the provisions of section 3b, read with section 1, 4, 5, 8, and 9 of the regulations of the Foreign Military Assistance Act 15 of 1998. Count 3, contravening the provisions of section 128a, read with section 1, 103, 117, 121a, and section 121, read with schedule 4 of the Firearms Control Act 60 of 2000. The bail application falls within the ambit of schedule 6, where the applicant bears the onus of proof on balance of probabilities that exceptional circumstances exist which in the interest of justice permit the release on bail pending the finalization of the investigations and trial in this case. The applicant was arrested on the 3rd day of January 2025 and has since been in custody. The applicant is represented by Advocate Razak and the state is represented by Advocate Mareume. I hope I pronounced your surname correctly this time. The question to be determined by this court is whether the applicant has adduced sufficient evidence to satisfy this court that exceptional circumstances exist which in the interest of justice permit the release of the applicant on bail. The right of the accused to be released on bail pending finalization of the investigations and prosecution in this criminal matter is a fundamental right enshrined in section 35 of the Constitution, and the main consideration of the bail application is whether the accused will stand trial. What is required of the court in bail stage is not to determine the issue of guilt, but to determine where the interest of justice lies in relation to bail. The court is required to exercise the value of judgment in accordance with all the relevant facts and circumstances, and that bail is never used as a form of anticipatory punishment. The defense led evidence on behalf of the applicant by way of an affidavit in support of his bail application, which formed part of the court records as Exhibit A and placed the personal circumstances of the applicant on record, however was not subjected to cross-examination by the state, more so that it ran the risk of having a probative value of such evidence being weaker than oral evidence. The personal circumstances of the applicant will not be repeated in its entirety here for the sake of convenience, and the following were placed on record. The applicant is a 35-year-old married to Farnaz Daoud and have no children, and currently residing at number 137 First Road, Defense Complex, Unit 25, Limbro Park, Sandton, which he is renting and is residing with his wife, who is fully dependent on him. His elderly father and mother, aged 70 and 60 years, respectively, also reside in the same complex and who are physically and emotionally dependent on him. He is employed as an independent contractor and consult for Choice Aluminium and earns an approximately 40,000 rand per month. He has a valid passport, which he has since surrendered it to the authorities. He has traveled to Lesotho, China, and Saudi Arabia, however, have never been domiciled out of the borders of the Republic of South Africa and regard South Africa as his permanent place of residence, and appears before this court with no previous convictions, no pending cases, nor any warrants of arrest against him. The applicant further placed the following on record: that he remained easily traceable in the Republic despite the allegations that he committed an offense in 2017. He remained at his fixed address even though the allegations were brought to his attention in a form of search and seizure warrant in October 2024. The state is mistaken in the allegations against him and have blown the matter out of proportion, and have cooperated with the SAPS since the allegations were leveled against him. And further, that the state has endorsed his liberty since 2017, and that he had undergone a cornea transplant approximately 10 years ago. Though it was successful, he often goes to checkups for monitoring, which required him to wear special lenses for the rest of his life. The applicant is not a flight risk, as he is easily traceable and the state case is weak. The applicant made the following submissions in terms of section 64A to E of the CPA, and same will not be repeated in its entirety here for the sake of convenience, that the interest of justice permits his release on bail, in that there's no likelihood that if released on bail, he will endanger the safety of the public or any particular person or commit Schedule 1 offense. There's no objective facts to show that he has propensity to commit any offense as he stands before this court as a first-time offender. Though it is an allegation which he disputes that he committed an offense in 2017, the alleged offense is an isolated offense involving a single alleged transaction and therefore no propensity for him to commit offenses and or continue as an alleged terrorist funder from the objective facts. If he was a terrorist funder, he ought to have funded the alleged terrorist organization more than once and at least with more than substantial amount than 11,500 rands. Funding an alleged terrorist organization only once since 2017 does not show any affiliation or alliance with the terrorism, and that the applicant has a fixed address and is not a flight risk, and that he had made charitable donations during 2024. The state called investigating officer, Warrant Officer John Gezani Sitole, who deposed an affidavit which formed part of the court records as Exhibit A, and also testified under oath and was subjected to cross-examination by the defense. The investigating officer's testimony in chief will not be repeated in its entirety here for the sake of convenience, and the following were placed on record. That he is the investigating officer in this matter, that the accused was arrested on the 3rd day of January 2025, and that the accused is a South African and his identity was verified with the Home Affairs. That around May 2018, the Financial Intelligence Center, again referred to as FIC or FIC, alerted the Directorate of Priority Crime Investigations, again referred to as DPCI, and the Crime Against the State Unit, again referred to as CATS, C-A-T-S, about the terror financing activity report that was reported by Luno, a crypto asset service provider, and on the 8th of February 2018, which according to the report, the suspicious transaction was made by the accused. On the 30th of November 2017, the accused transferred an amount of 11,500 rand from his First National Bank account, which with the account number 62128783,972 to his Bitcoin account with Luno, with the pay reference number BX669KFKA. And on the same day, he purchased a Bitcoin worth 11,500 rand, which he transferred to Bitcoin wallet address of the following: 15, capital letter K, 9, capital letter Z, small letter J, 1, capital letter A, U, 2, small letter H, J, capital letter T, 3, small letter E, B, capital letter Z, M, small letter T, capital letter W, small letter Q, capital letter D, small letter S, capital letter M, small letter V, and 3, small letter F, capital letter F, small letter X, capital letter T, N, small letter W, small letter P, small letter F, being the herein referred to as the Bitcoin wallet address. And that the conducted investigations revealed that around 2017, an advert was posted on social media platform in Telegram, Facebook, and Twitter by Al Sadaqah, organization who requested those who want to assist, and I quote, Mujahirin in Syria with weapons, financial aid, and other project assisting the jihad, close quote, to donate safely and securely with the Bitcoin provided the Bitcoin wallet address. And the advert was attached as Annexer JGS1 in the investigating officer's affidavit. That the accused is linked to the offense in that on the 25th day of September 2024, the state obtained a search and seizure warrant from Randburg Magistrate Court and was executed on the 30th day of October 2024 at the residential address of the accused, whereby evidential material was seized. The analysis report from Digital Forensic Lab indicated that the accused cell phone contained, among others, 3 times images similar to that of Annexer JGS1. The United States of America has listed the said Bitcoin wallet address as number 79 on the 155 wallet addresses linked to ISIS, and the said list was admitted in court as Exhibit C. Further, in his testimony in chief, the investigating officer made the following submissions in terms of Section 64A to E of the CPA, and same will not be repeated in its entirety for the sake of convenience. That there is likelihood that the accused, if released on bail, will attempt to evade his trial, and that the accused does not have a stable address, and the 3 addresses appear on his profile, and that his current address at Limbro Park does not appear on his profile and did not inform the district firearm office in Lichtenberg and Sandringham offices about the changes of his residential address. The accused has connections outside the borders of the Republic, as the headquarters of the company that the accused is employed are based in Lesotho. The seriousness of the offense in which the accused is charged, that the offense are of serious nature, and count 1 and 2 emanates from United States Security Council treaties, and that should the accused be convicted, is likely to be sentenced to a minimum of 15 years imprisonment. And the strength of the case against the accused and the incentive that he may consequence have to attempt to evade trial. The state has a watertight case against the accused, and that can influence him to evade trial if bail is granted. Section 64E, the offense of terrorism finance are of serious nature, and that experts regard South Africa as a hub for mobilizing financing for terrorists. As a result, the conduct similar to that of the accused has led South Africa being grey-listed by Financial Action Task Force. And further, that a period of 4 weeks was required to complete the investigations. Furthermore, the investigating officer testified that on the 27th day of June 2024, the accused applied for a firearm license and provided an address he was not residing at, being number 27 Carroll Road, Robertsem in Johannesburg. He does not have any possible addresses outside the Republic, and that the advert that the accused sent money to has nothing to do with the charity organizations, and as one wants to believe that Al Sadaqah is a charity organization, but the people behind it, those who have posted the advert on a public platforms, they are requesting weapons, ammunition, and financial aid. The law does not require investigating the listed organization. Even the activities are investigated. And during cross-examination, the investigating officer testified that he is not a historian on Syrian conflict, and that the accused is not charged with or appearing before this court on a charge of falsely applying for a firearm, and that the investigating officer does not have a problem with any of the remaining sections of Section 64A to E of the CPA except the flight risk. With regards to the strength of the state case, the applicant intends to plead not guilty to the charges against him, and that the case against him is weak. However, the state argued that it has a strong case against the applicant. There is no obligation on an applicant for bail to challenge the strength of the state case, as stated in Panayato versus the state at paragraph 56. If the applicant does choose to challenge the strength of the state case against him in bail proceedings, then he attracts a burden of proof to show that there is a likelihood that he will be acquitted at trial. And also in the Panayato versus state, the court held that in order to enable the court to come to the conclusion that the state case was weak or that he was likely to be acquitted, he was required to adduce convincing evidence to establish this. Section 60 of the Criminal Procedure Act governs and embodies all the applicable principles that should guide the release of the accused on bail. And the Section 60 of the CPA divides all the crimes into 3 categories for the purpose of bail, based on the gravity and seriousness. Section 6011A provides as follows in respect of Schedule 6 offences. That the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, and unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permits his or her release on bail. In terms of the provisions of Section 6011A, the accused accordingly bears the onus to adduce evidence which shows that exceptional circumstances exist which in the interest of justice permits their release on bail. Although it is a fundamental right of any accused to be released on bail, if the interest of justice so permits, the right of the accused to be released on bail has thus been stringently limited in respect of serious offences, which limitation has to stand the constitutional scrutiny. And I specifically refer to the case of State versus Dlamini, State versus Kladla and others, State versus Chubet, and also in State versus Kitegat. Section 6011A contains two separate requirements which an accused must establish on a balance of probabilities. Firstly, that the exceptional circumstances exist which justifies the release on bail, and secondly, that such exceptional circumstances justifies the release of the accused in the interest of justice. And there is no onus on the state to disprove exceptional circumstances. As to what will constitute exceptional circumstances, this has to now be referred to factors which are unusual or typically out of ordinary, rare or peculiar. And the cases of Director of Public Prosecution versus Nkaloin and another refers to this, as well as State versus Mukhoji. Exceptional circumstances need, however, not to fall into extraordinary class. There may be factors which in the circumstances of the particular case constitute exceptional circumstances, or simply put, ordinary circumstances present to an exceptional degree may lead to a finding that the release of the accused on bail is justified. And the personal circumstances which are really commonplace can, however, not constitute exceptional circumstances for the purpose of Section 6011A. In State versus Scott Crossley, the court states that an accused personal circumstances which are commonplace do not necessarily constitute exceptional circumstances for the purpose of Section 6011A. I agree that the sentiment expressed by the appeal court applies in this matter. The exceptionality of the circumstances must be such as to persuade that the court that it will be in the interest of justice to draw up a bail. The court will now apply the above law to this bail application and will look whether the applicant has crossed the first hurdle, which is the exceptional circumstances. And in considering of all the above, it is the applicant who bears the onus of proof to prove existence of exceptional circumstances, and there's no onus on the state to disprove the exceptional circumstances. Section 64A of the Criminal Procedure Act provides that the interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established. Nay, where there's likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense. And then B, where there's likelihood that the accused, if he were or she were to be released on bail, will attempt to evade his or her trial. Or where there's likelihood that the accused, if he or she were to be released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Or where there's likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. The court will now apply the above law to this application and will look whether the applicant has crossed the second hurdle that exceptional circumstances justifies the release of the accused in the interest of justice. Section 64A read with Section 65A to H, where there's likelihood that the accused, if released on bail, will endanger the safety of the public or any particular person will commit or will commit a Schedule 1 offense. Section 65, in considering whether the grounds in subsection 4A has been established, the court may, where applicable, take into account the following factors, namely the degree of violence towards other implicit in the charge against the accused, any threat of violence which the accused may have made to any person, any resentment the accused is alleged to harbor against any person, any disposition to violence on the part of the accused as is evident from his or her past conduct, any disposition of the accused to commit offenses referred to in Schedule 1 as evident from his or her past, the prevalence of a particular type of offense, and any evidence that the accused previously committed an offense referred to in Schedule 1 while released on bail, or any other factor which in the opinion of the court should be taken into account. Section 64B read with Section 66A to J, where there's likelihood that the accused, if released on bail, will attempt to evade his or her trial. Section 66, in considering whether the grounds in subsection 4B has been established, the court may, where applicable, take into account the following factors, namely the emotional, family, community, or occupational ties of the accused to the place at which he or she is to be tried, the assets held by the accused and where such assets are situated, the means and travel documents held by the accused which may enable him or her to leave the country, the extent, if any, to which the accused can afford to forfeit the amount of bail which may be set, the question whether the extradition of the accused could readily be affected should he or she flee across the borders of the Republic in an attempt to evade his or her trial, the nature and gravity of the charge on which the accused is to be tried, the strength of the case against the accused, and the incentive that he or she may in consequence have to attempt to evade his or her trial, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted of the charges against him or her, the binding effect and enforceability of the bail conditions which may be imposed, and the ease which such conditions may be or could be breached, or any other factor which in the opinion of the court could be taken into account. Section 64C read with Section 67A to H, where there's likelihood that the accused, if released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Section 67, in consideration of whether the grounds in subsection 4C has been established, the court may, where applicable, take into account the following factors, namely the fact that the accused is familiar with the identity of the witnesses and with the evidence which they may bring against him or her, whether the witnesses have already made statements and agreed to testify, whether the investigations against the accused has already been completed, the relationship of the accused with the various witnesses and the extent to which they could be influenced or intimidated, and how effective and enforceable bail conditions prohibiting communication between the accused and the witnesses are likely to be, and whether the accused has access to evidentiary material which is to be presented at his or her trial, and the ease with which evidentiary material could be concealed or destroyed, or any other factor which in the opinion of the court should be taken into account. Section 64D read with Section 68A to D, where there's likelihood that the accused, if released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. Section 60A is in considering whether the ground in subsection 4D has been established. The court may, where applicable, take into account the following factors, namely the fact that the accused, knowing it to be false, supplied false information at the time of his or her arrest or during the bail proceedings, whether the accused is in custody on another charge or whether the accused is on parole, any previous failure on the part of the accused to comply with bail conditions or any indication that he or she will not comply with the bail conditions or any other factor which in the opinion of the court should be taken into account. Section 64E read with Section 68, capital letter A to F, where in exceptional circumstances there's likelihood that the release of the accused will disturb the public order or undermine the public peace or security. Section 68, capital A, in considering whether the grounds in subsection 4E has been established, the court may, where applicable, take into account the following factors, namely, where the nature of the offense or the circumstances under which the offense was committed is likely to induce a sense of shock or outrage in the community where the offense was committed, whether the shock or outrage of the community might lead to public disorder if the accused is released, whether the safety of the accused might be jeopardized by his or her release, whether the sense of peace and security among members of the public will be undermined or jeopardized by the release of the accused, and whether the release of the accused will undermine or jeopardize the public confidence in the criminal justice system, or whether any other factor which in the opinion of the court should be taken into account. In the above, the investigating officer in his testimony testified that he has no problem with the remaining factors of section 64A to E except the flight risk. On whether the applicant is a flight risk, the state has failed in justifying the same, and the argument that was raised by the state is that the accused has ties to Lesotho, and as the company that he is employed at has its headquarters in Lesotho, and further that there's no treaty between South Africa and Syria, making it impractical for the accused to be extradited should he evade trial. Further, that the accused, upon his firearm application, he did not provide his current address as his place of residence, and it should be noted that the charges that the accused is facing before this court are the only ones that were mentioned earlier on. The accused has since surrendered his passport to the authorities. The accused was arrested at his place of residence and was even cooperating when the search and seizure operation was conducted until his arrest. And that there's no satisfactory evidence that was tendered before this court on the following factors: the likelihood that the accused, if released on bail, will endanger safety of the public or any particular person, or will commit Schedule 1 offense; the likelihood that the accused, if released on bail, will attempt to influence or intimidate the witnesses or to conceal or destroy evidence on the and the likelihood that the accused, if released on bail, will undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system; the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. It is clear from the provisions of Section 69 and Section 6010 of the Act that a court has the duty to weigh up the personal interest of the accused against the interest of justice in both opposed and unopposed bail applications. This, it is submitted, implies that the criterion of the interest of justice is not an absolute one that would, for instance, once met, necessarily relieve the state of its burden of proof in terms of Section 61A of the Act. And that once the state has succeeded in showing that on balance of probabilities, the interest of justice will be best served by the accused further detention, it is incumbent upon the court to bring the provisions of Section 69 into the equation before it makes its final adjudication. Section 69 of the Act reads as follows: that in considering the question in subsection 4, the court shall decide the matter by weighing the interest of justice against the right of the accused to his or her personal freedom, and in particular, the prejudice he or she is likely to suffer if he or she were to be detained in custody, taking into account where applicable the following factors: the period of which the accused has already been in custody since his or her arrest, the probable period of detention until the disposal or conclusion of the trial if the accused is not released on bail, the reason for any delay in the disposal or conclusion of the trial and any fault on the part of the accused with regards to such delay, any financial loss which the accused may suffer owing to his or her detention, and any impediment to the preparation of the accused defense or any delay in obtaining legal representation which may be brought about by the detention of the accused, and the state of health of the accused or any other factor which in the opinion of the court should be taken into account. It will be noted that the legislature has seen fit to make this mandatory provision which must be applied by a court considering the interest of justice in terms of Section 64 of the Act. Section 6010 goes one step further. Even where the state does not oppose bail, a duty is imposed upon the court to weigh up the personal interest of the accused against the interest of justice. This means that the bail may never be there for the mere asking, and that the court should always, in adjudicating, strike a balance between the interest of justice and the interest of accused, as envisaged in Section 69 of the Act. And much of the subject matter of Section 69 may be traced back in the judgment of State versus Eckerson. The refusal to grant bail and the subsequent detention of an accused shall be in the interest of justice where one or more grounds listed in Section 64 of the Criminal Procedure Act is or are established. As such, the court is satisfied that He has proven exceptional circumstances before this court and on balance of probabilities and thus have crossed the first hurdle. And I'm of the view that the applicant's submissions sufficiently constitute exceptional circumstances on balance of probabilities which warrant the release of the applicant on bail in the interest of justice and thus have crossed the first hurdle. The state has failed to prove on balance of probabilities the factors or grounds as stipulated in section 64A to E of the Criminal Procedure Act, being the cornerstone of our law for the purpose of bail application, which justifies the release of the accused on bail. And all these factors cumulatively, you may stand up, sir. And all these factors cumulatively weigh more in favor of the applicant being admitted to be released on bail, and therefore the applicant's release on bail will be in the interest of justice. As such, the applicant have satisfied the ground listed in section 64A to E of the Criminal Procedure Act, and the court is satisfied that he has proven exceptional circumstances before this court and thus have crossed the first and second hurdle. And as a result, the bail is granted and it is fixed at an amount of 30,000 rand with the following conditions: not to interfere with the police investigations, not to interfere with any of the witnesses, not to commit any of Schedule 1 offenses while released on bail, to report to Santon Police Station on Mondays, Wednesdays, and Fridays between the hours of 8 in the morning and the hours of 1700 in the afternoon. And the applicant to send a live location via WhatsApp to the investigating officer upon request, and the applicant's passport to remain so surrendered and in possession of the investigating officer, and to attend all court proceedings until the matter is finalized.
As it pleases the court. Thank you, Worship. May this matter be a remand for investigations to the 3rd of March. 3 March. The date has been discussed with the defense. As it pleases the court.
And what is outstanding?
Pardon me.
What is outstanding?
Your Worship, at this moment, I don't have the docket with me because Advocate Marume is the one who's handling the matter, and the only thing that I had is the charge sheet, so that it was just for judgment on bail to be delivered. I never perused the docket. It's with Advocate
Defense?
As it is.
My attorney had communicated with our friend from the TPP's office. This date with the 3rd of March has been agreed between the both of us. I'm not sure if it's going to be on the next occasion, but this is the date he suggested by agreement. Regarding the investigations, I have no indication of what's still outstanding, but he indicated that investigations ought to be complete within this 4-week period. However, he may address you on the next occasion.
The matter is then postponed to the 3rd day of March 2025 for further investigations, and we are on for 8:30 should we pay the bail money. Do you understand?
Your Worship, State makes an application for 10 minutes break, adjournment, so that the media personnel can just pack their belongings so that we can restart our matters.